This morning at exactly 10:03 a.m. Eastern Time, the Supreme Court of the United States issued one of the shortest rulings imaginable, yet one of the most consequential in recent memory. The court denied an application in a major federal legal case. There was no written opinion. There was no explanation. There was no dissent. All 9 justices agreed. The ruling consisted of just 2 words: application denied. That single sentence brought months of legal maneuvering, procedural delays, and emergency motions to an abrupt end. With those 2 words, the Supreme Court closed the final door that had remained open for the defense. No more appeals, no more pauses, no more procedural shields. The legal process now moves forward without obstruction. What makes this ruling especially significant is its timing. It came exactly 72 hours after Melania Trump's legal team submitted a formal proffer agreement to federal prosecutors. In that agreement, she outlined the evidence she is prepared to provide and the testimony she is willing to give in exchange for potential immunity from prosecution. 2 major legal events, both extraordinary on their own, occurred within 3 days of each other. The sequence and timing strongly suggest they are directly connected. Before anyone dismisses this as speculation, it is important to understand where this information comes from. These details are not rumors. They are not anonymous leaks. They are not based on unnamed sources. Everything being discussed comes directly from court filings, sworn statements, official agreements, and Supreme Court orders. Anyone can access them, read them, and verify them independently. Here is what has now become legally established. Melania Trump has voluntarily waived spousal privilege. Spousal privilege is a long-standing legal protection that generally prevents prosecutors from forcing one spouse to testify against the other. It exists to protect marital trust and privacy. But this privilege does not belong to the defendant. It belongs to the witness spouse, and it can be waived voluntarily. That is exactly what happened here. According to the proffer agreement, the evidence she is offering falls into 3 distinct categories. The first category involves financial documents that reportedly demonstrate her awareness of dishonest property valuations. Between 2014 and 2020, she signed 6 consecutive years of joint tax returns. These filings were signed under penalty of perjury, meaning both spouses legally affirmed that the financial information contained in those returns was accurate and truthful. Joint tax returns rely heavily on asset valuations, how much properties are worth, how much income they generate, and how deductions are calculated. If properties were presented to banks at inflated values to secure favorable loans, while those same properties were reported at lower values to tax authorities to reduce tax liability, that conduct potentially constitutes bank fraud and tax fraud. A signature on a joint return creates legal exposure for both signatories. The proffer further states that she attended meetings with accountants where property valuations were actively discussed. She did not merely sit in silence. She asked questions. She sought clarification about how certain assets were being reported. Prosecutors already possess emails supporting these claims. The second category of evidence involves communications. This includes text messages exchanged between her and the defendant, discussing property values in advance of meetings with lenders. It also includes email correspondence with accountants, where she questioned discrepancies between figures presented to banks and figures reported on tax filings. In addition, the proffer references recorded phone conversations in which specific property values were discussed in connection with loan applications. In federal cases, recordings are admissible when they comply with consent laws. The fact that these recordings are being offered in a proffer strongly suggests prosecutors have already authenticated them and verified their legality. The third category is witness corroboration. She is prepared to confirm testimony already given under oath by accountants, bankers, and property appraisers. Corroboration is critical in federal prosecutions. One witness describing this conduct is powerful. Multiple witnesses independently confirming the same events is far more powerful. When documents, recordings, and testimony all align, a pattern of evidence emerges that is extremely difficult for any defense to overcome. Buried within this proffer is what many legal experts consider the most stunning development of all: the voluntary waiver of spousal privilege. This is not a case of prosecutors forcing cooperation. There was no subpoena. There were no threats. There was no coercion. According to a sworn statement from her own attorney, she initiated contact with the special counsel's office. Her legal team proposed cooperation. Her legal team negotiated the terms. Spousal cooperation is not unheard of. It has occurred in organized crime prosecutions, where spouses testified to protect themselves from legal exposure. It has occurred in corporate fraud cases where executive spouses shared liability due to signed documents or financial involvement. But what makes this case unprecedented is the level of power involved. Never before has the spouse of someone who once held the highest office in the United States come forward with financial records, communications, and sworn testimony in a federal criminal investigation of this magnitude. The defendant's legal team attempted to stop this through an emergency appeal to the Supreme Court. That appeal was filed on Tuesday afternoon, just 24 hours after the proffer was submitted. The speed of that filing strongly suggests the defense anticipated this development and prepared in advance. The appeal made 3 central arguments, and all 3 failed. The first argument claimed that spousal testimony violates marital privacy protections under the Fifth Amendment. This argument directly contradicts over 150 years of Supreme Court precedent. The controlling case is Trammell v. United States, 1980, which clearly established that spousal privilege belongs to the witness spouse alone. If the witness chooses to testify, the defendant cannot block it. This ruling has never been overturned and is uniformly followed by every federal circuit court. The second argument claimed that the proffer agreement was the result of coercion or prosecutorial pressure. That claim collapsed immediately. The sworn statement from her attorney confirms that she reached out first, proposed cooperation voluntarily, and negotiated the terms without threats or compulsion. Federal courts apply a clear standard when evaluating voluntariness, and every element of that standard was satisfied here. The third argument warned that allowing this testimony would create a dangerous precedent undermining marital privacy nationwide. But that precedent already exists. Spouses testify voluntarily in federal cases every year. What the defense was truly seeking was a special exception based on the defendant's identity. The Supreme Court does not grant exemptions based on status, wealth, or power. On Wednesday, the Supreme Court received the appeal, assigned it a case number, and critically, did not issue a stay. A stay would have frozen the legal process. The court's refusal to do so was a strong signal that the appeal lacked merit. Then, on Thursday morning at 10:03 a.m., the court issued its final ruling. Application denied. No dissent, no explanation, no debate. In over 3 decades of legal observation, this type of unanimous, one-line rejection is extremely rare. When the court believes an argument has substance, it writes, even briefly. When it does not, silence speaks volumes. This ruling sent a clear message. The appeal was not merely weak, it was frivolous. With that denial, the grand jury is now free to hear her testimony. In the Southern District of New York, grand juries typically meet on Tuesdays and Thursdays. If prosecutors are ready, and the proffer indicates they are, her testimony could occur within days. Prosecutors now face a strategic decision. They can use her testimony to strengthen the existing charges, which already include 34 counts of falsifying business records and bank fraud. Or they can seek a superseding indictment, adding new charges based on the evidence she provides. One detail to watch closely involves a phone conversation from March 2020. According to the proffer, she was present during a call between the defendant and a banker, where property values were discussed in connection with a loan application. If both knowingly misrepresented facts, that could constitute conspiracy to commit bank fraud, a separate and serious offense. The trial is currently scheduled for September 16th, roughly 28 weeks away. With the Supreme Court's denial, there are no remaining legal mechanisms to delay it. This case establishes 3 powerful precedents. First, it confirms that spousal cooperation can occur even at the highest levels of political power. Second, it signals that privilege claims will not be used as delay tactics in federal prosecutions. Third, it reinforces the principle that accountability applies equally, regardless of wealth, influence, or status. Over the next 30 days, 3 developments will reveal the prosecution's direction: grand jury activity, defense motions, and the finalization of any immunity agreement. The Supreme Court did not write an opinion because none was needed. The law was already clear. Privilege can be waived, evidence will be heard, and no one stands above the law.